What happens after a federal arrest in South Carolina? Most people don't get notice of a federal arrest, especially in South Carolina. And so a lot of times the first thing they find out regarding an investigation is when they get arrested. And obviously that can be traumatic. That causes a lot of panic. But as soon as someone is arrested, they usually are seen by a federal magistrate judge within 24 hours. And then at that hearing, at that initial appearance, two critical things happen. First, the charges are read to the individual. They're informed of the charges against them and the potential penalty. A not guilty plea is entered. And then almost immediately after that, bond is taken up. When I say bond in federal courts, the terms bond, the terms bail are sort of used interchangeably. But essentially, it's a hearing in front of the magistrate court judge to determine whether a person should be detained or held without bond, or whether they should be given some type of bail that allows certain conditions for them to not be detained. Now, the government usually makes a motion for a bond at that point in time. They can seek detention, which is, again, being held without bond or without bail. If they seek detention, the other side or both sides usually are entitled to 3 days for that detention hearing to happen. So the detention hearings sometimes happen at the initial appearance or within 3 days, or if that 3 days is waived at a later date. The detention hearing is very important. At that point in time, the judge considers certain statutory factors, but what they boil down to in federal court and generally in state court is the person's risk of flight and danger to the community. Now, what type of factors go into that consideration? Obviously, the facts of the crime. Okay, so the more serious the offense, obviously the greater danger the person may pose to the public. Obviously, the more trouble they're in based on the potential penalty, the greater the risk of flight. So the court's going to look at, first of all, the charges and the seriousness of the offense and the conduct involved. They're also going to look at sort of more traditional things, ties to the community, criminal record, family support, financial ability, which means sometimes the ability to flee, or ties to other countries or ties to other states. So the judge will consider all of those things. Now, how is that evidence presented? Generally, it's presented through a summary witness. Usually that's a case agent that investigates the case. So most of the time, the government, at least in South Carolina, will present a witness. And importantly, the defense lawyer has a chance to cross-examine that witness. A lot of times, that's the first opportunity to learn about a case, to learn some of the facts that are involved. So the detention hearing can be a good opportunity to learn the basic facts of the case, especially when a person doesn't know what they're really charged with beyond what's been listed in the indictment, and that indictment can be pretty vague. There's also an opportunity to proffer the evidence. Defense attorneys often waive a witness, and there's some strategic reasons for that. But the prosecutor can also proceed by proffer, where they tell the judge, essentially, the prosecutor tells the judge what facts are contained in the case. Also a good chance to learn about what the case is about. So based on that information, the judge will make a ruling, a ruling based on the need for detention, and understand certain cases, certain charges contain a presumption of detention, mostly drug cases that carry a certain amount of time, over 20 years, and some gun charges. So there are some special federal charges that carry a presumption of detention, but for the most part, the judge will consider risk of flight and danger to the community, and there's an open hearing where the defense lawyer gets a chance to cross-examine the witness to determine what exactly is involved and how serious the offense is. Also, it's good to have family members there. It's good to have folks there to speak, if necessary, about the person's risk of flight, danger to the community, or that there'll be somebody who can look out for that person. If the judge grants bond in South Carolina in federal courts, it's called unsecured. In state court, it's a PR, a personal recognizance bond. Certain conditions will be placed. Usually that's to not use drugs, not break any laws, and sometimes like a GPS monitor is installed. And if the person is not granted bond, if they're detained, that can always be revisited, but usually when there's a change of circumstance. So that's kind of what goes into the bond hearing and the initial appearance. It happens right after arrest, the initial appearance, and then usually within 3 days of the initial appearance is the bond hearing. If anybody has any questions or needs any help regarding a detention hearing, a bond hearing, or any initial appearances or new arrests in South Carolina, please give us a call. Our number is 843-473-7000.